So what are the 5 documents you need? You need a will, a revocable trust, financial powers of attorney, healthcare directives, healthcare power of attorney. And finally, if you have minor children, you must name guardians. There's more documents and more bells and whistles behind each one of these, but together they talk to each other and protect your legacy, right? Who wants to leave a messy legacy? So, what is a will? Everyone says the reading of the will. I just love this picture. It depicts all the greedy family members coming around. These people are sitting around and want to know what they're going to get. They want to put their greedy hands and paws, as I like to say. I think that dog should get everything, right? But anyway, what does a will do? A will says who gets what and how much they get, because a will does not hold title to any assets. So therefore, probate's triggered. If you don't have a will, then you can't sell the property when somebody dies, because the person that died cannot sign the deed or the escrow instructions or get a loan. It's impossible. So somebody has to act on your behalf when you're dead, and that's the executor or the administrator that has been appointed. This is a public process. Who wants to air their dirty laundry to the public? So a will does not avoid probate, and this is all available to creditors, and creditors can make their claim. So again, this reading of the will, all the greedy people coming around, they really don't read the will. Yes, you have to send it out, and sometimes people will put some clauses in their will or trust that they want everyone to gather around. And sometimes they do want to do it like the movies, but normally it's not. So, how do you avoid probate? You avoid it by having a revocable trust, and it has to be funded. A trust avoids probate if your assets have been transferred to that trust. Your affairs are private. It doesn't get published. It doesn't get recorded in any iCloud or anything like that. And it passes on your legacy without, hopefully, any litigation. It preserves your assets for future generations. Believe it or not, yes, it's a little bit of managing from the grave, but you can protect your family, whether it's your nieces, your nephews, your grandchildren, your children, right? And potentially this money can go on for multiple generations if it's managed correctly. And not all trusts are the same. And you can add provisions in your trust so that your daughter, your son doesn't have the right to go buy an Aston Martin when they're 18, or that maybe you want to pay for college, but you don't want to pay for graduate school. Again, it depends on what your estate is worth, what's the value, and what are your values. So we put your values into the revocable living trust. If it's a blended family, you want to make sure that his, hers, and theirs, all of the children are protected. And you can do that by having a revocable trust. You can do that making sure that if you have separate property, that there's a prenup or a postnup that passes on to your children or grandchildren, so that it's not lost in divorces, because that is the biggest cut of preserving assets, right? You get a divorce, we live in California, everything's community property. I just want to make a note on that. Your inheritances are your separate property, sold separate, unless you commingle it. And so as soon as you commingle it, it becomes community property. People can say, oh, no, this was received from my grandmother, my mother, my father, grandpa. It doesn't matter. As soon as you commingle it, all bets are off. So you want to keep it in trust. You can also segregate it so that a beneficiary will receive an asset at 25, 30, 35. Maybe they're more mature at that time. Or you give it to them in trust, and they will be their sole trustee when they're 30 or 35. And yes, they're in charge of it, but it's asset protected. So it's protected against divorces and some potential creditors as well. So really the trust, it's a private document, and it's a way to protect your heirs and also to preserve your legacy. What is the other document you need to have? So remember, the first one was a will, then a trust, and now it's the durable power of attorney. So what is a durable power of attorney? So a durable power of attorney means that someone can step in and manage those finances even if you're incapacitated. And so this would be, let's say you have a retirement account, whether it's a 401k, a 403b, or an IRA, and you're incapacitated. Well, you have to make minimum distributions, RMDs. Somebody has to do that if you're incapacitated. So you are the principal. Then your attorney, in fact, is your agent, and they can file tax returns for you. They can make the withdrawal from the retirement account. They can make sure your bills are being paid, the lights are on, you have food in the refrigerator, or if you're in a facility, they can pay the bills for you. They step into your shoes and manage all of your assets. Now, many people will say, well, I don't need that because I'm married, or my mom or dad is still alive, or I'm only 18. My mom or dad can just step in. Wrong, wrong, wrong. Just because you're married, your spouse is not automatically your attorney in fact. Just because you're a life partner, your life partner is not automatically your attorney in fact. Just because you're 18, 19, 20, 21, your parents are not automatic in managing your finances, and they are not your attorney in fact. This has to be documented. And I promise, I'm not just saying that because I'm an attorney. And not all powers of attorneys are the same, too. You can designate what you want your agent to be able to do and not do. If you don't have this and you have assets like a 401k or a IRA, 403b, it doesn't matter. Any retirement account, and you become incapacitated, no one can get to those funds. So you have to go to court and you request to have a conservatorship appointed, right? So that is a conservator is appointed over you that's incapacitated, and it's a conservatee. And it can be very difficult to get because you have to have a capacity declaration. You have to be deemed incapacitated, and it costs a lot of money. It's costing somewhere between $500 and $7,500 and above. And if it gets litigated, if family members are fighting over who's going to be in charge of your finances, oh my goodness, it goes into litigation. It can be a trust dispute while you're alive and you're in probate. So that's even worse. You're alive and your assets are going through probate. Oh my goodness. You want to avoid that like the plague, right? That is just not something you want to happen, especially it's probably getting closer to your end of life. Or if there was a health issue that happened earlier, then the court will be in charge and have to oversee this conservator until you pass. There's no deleting the conservatorship once you've opened it. It's complicated, right? You have to file an accounting and you have to pay the bills for the conservatee. It's something you want to avoid as well. Your advanced healthcare directive and your healthcare power of attorney. So now taking care of your health. If you're 18 or older, you need to have this. And what is this? What is the healthcare document? So one is a healthcare directive. That's end of life decision. Life support, no life support, close to death, in a coma. You make your wishes known to your family members. Healthcare power of attorney is over your health. So let's just say you're incapacitated, you have a cognitive issue, whether that's Alzheimer's, dementia, or some sort of cognitive issue that you cannot make healthcare decisions for you. And there's a really low threshold in making healthcare decisions for yourself. So you just want to make sure that your wishes are carried out so that if you're unable to make decisions, your family members, friends, whomever that may be, can follow your wishes. And then finally, the HIPAA release. You want to make sure that certain people have the right to your medical records, dealing with insurance company, making sure that your insurance is paying for whatever care you are getting. If you have long-term care, you want to make sure that at a minimum, you have these 3 documents in place. And this avoids a conservatorship because you could go to probate if you don't have these and medical decisions need to be made. Sometimes the healthcare profession will turn a blind eye, but many times they won't. And you'll have to go to probate in order to get the conservatorship, in order to make healthcare decisions for your loved one. And again, you want to avoid that. You don't want to be stuck in probate. Finally, those of you with minor children, or if you know someone with minor children, please make sure they have guardians named. And the guardians are custodial guardians and financial guardians. So we have 2 guardianships that we like to do, the short term and the long term. Short term is someone that can get to your children within 20 minutes, right? It's a family, it's friends, it's neighbors. It does not have to be a family member, nor does it have to be the person that is going to raise your children should the unthinkable happen to you, right? As a premature death. And then, of course, there's the long term. So, long term is who's going to raise your children if you're unable to. And this should be someone that shares similar morals, values, spiritual needs, someone that's going to raise your children the way you wanted them to be raised. If you don't name guardians, guess what? A judge will decide who is going to be the guardian of your children. And so maybe it would be your brother, your sister, your brother in law, your sister in law, but maybe it's someone else that came forward because what happens is a judge will send out social workers to everyone that came forward. They do an evaluation. They look at the evaluation and they say this person or that person, and that's it. End of discussion. That's who's going to raise your children. And it might not be the person you thought it would be. The judge doesn't know your morals and your values. And we had a situation where there was very amicable between her brother and her younger sister, but she thought her older brother was raising very bratty kids. They had a great relationship, but she did not want her brother to raise her kids. But he was married, had two kids of his own. His wife was stay at home. He was a banker. Money was not an issue. Then her younger sister was just graduated from college, trying to find herself, didn't know what she wanted to do. But guess what? She wanted her younger sister to raise her kids because she knew her younger sister would raise them the way she would want them to be raised. And that's where life insurance plays a big part. And so that's another whole discussion as well. Life insurance is a great way to up your estate. And I don't sell life insurance whatsoever, but I'm a big proponent of it. So without a short-term plan, this is what happens, right? Babysitter receives a phone call from a parent. Oh my goodness, where are they? They have to call the police. They call Child Protective Services. And that is until the temporary guardians can get there, which may be short period or long period of time. And then again, this can create a lot of chaos if you don't have anyone named. And so by naming short-term guardians, this is a way to avoid all of this so that your short-term guardian can say, here's the documentation. And they said that I have the right to take physical custody of your children because you cannot release physical custody of a minor child without parental consent. So without a long-term plan, this crazy looking judge is going to make the final decision as to who is going to raise your children. And you might not like the plan. Yes, you might, but I don't know. I wouldn't want this judge making my decision. So make sure you have a long-term and a short-term.